Trial attorney Misty Marris is here right now with the analysis on all of this. Great to see you, Misty. I'm going to put excerpts up from those opening statements that Joe was alluding to. First, prosecutor Derek Hines. We would not be here today if he was just a drug addict. The defendant's choice to buy that gun is why we're here. Addiction is not a choice, but buying a gun is. And then Abby Lowell on the defense, they have to prove beyond a reasonable doubt that Hunter knowingly violated the law. And that's the point I'll pick up with you, Misty, Abby Lowell's point, that Hunter didn't knowingly break the law, as Joe reported, because he says he was clean at the time. He was in between relapses, and that's when he filled out the gun application. What do you make of that defense?
So there's a couple of different aspects of the defense. Number one is exactly as you said, Connell. The argument is going to be pay attention to the timeline. You're going to see a whole slew of evidence coming from the prosecution, pictures, text messages, a memoir. But what was Hunter Biden? What was his state of mind at the time he bought the gun? The defense is arguing that he actually went to rehab a month before and that he did not see himself as an addict when he filled out that form. The defense went so far as to talk about the exact language in the form and that addict is not actually defined. And it wasn't explained to Hunter Biden at the time what that term means. That's why you heard the defense hammer home this word, knowingly. It has to be knowingly. Essentially, what the defense is going to argue, Hunter Biden at the time in his mind was not an addict and therefore could not have knowingly lied on that form.
I also saw that there was an argument that Lowell was making that Hunter, the people who sold him the gun, the people that sold him the gun were kind of out to get him, might not be the right way, but just overly eager to sell to him because he was Hunter Biden and that they didn't follow all the protocols. So would that be a worthwhile defense worth pursuing as well?
Yeah, absolutely. So that's going to be a part of the case. And interestingly enough, the defense was trying to get in evidence of a second form. Okay, so there's one form. Stay with me, Connell, because this seems a little complicated, but it's actually going to be really important. 2018, the form that's on file, the form that's the subject of this case, Hunter Biden used his passport in order to obtain the gun. You have to show identification. That's the form that's on file. That's the form that's sent to the ATF. That's the form that's sent through all of the typical procedures and protocols. However, the shop also maintained another form which had a handwritten note on it from 2021. So the handwritten note was actually supplementing an address because they had actually not gone through that part of the protocol. There was no address because your passport does not have your address on it. The defense wanted to argue that the original application could have actually been falsified. They wanted to say that there's no way the prosecution could prove, because there was this annotated note, that the original form was even accurate. But the judge said no. Now we see the defense coming in with this kind of bringing it in through the back door, right, saying that they did not go through all the protocols because of this issue with the address, which they had admitted to federal prosecutors. They went back and did it because there was a lot of scrutiny on the case, and they wanted to make sure that they had their ducks in a row.
Interesting. One last thing, Misty, because there's comparisons made, obviously, because of the timing, 1 week after the other, between this trial and President Trump's trial. Big difference is obvious. One's a former president, one's the son of a president. But if they weren't, if it wasn't, I've heard some legal analysis already on this. Dan Abrams was saying it last night. If one wasn't, Hunter Biden, the other wasn't Donald Trump, would either of these cases been brought? How do you see that part of it?
So Donald Trump, I really, the uniqueness of that case with the falsification of business records, there's never been another case like that in New York State. So unless it's Donald Trump, I don't know if you see that case coming into the courtroom. This one is also unique in that way because this statute about lying on the gun application and then possessing the gun is usually not charged on its own. It's usually because somebody who has a gun was either a convicted felon, wasn't supposed to have it, or the gun was used in another violent crime. So it is unique in that sense that it's being charged without that second piece of it, which is usually the primary crime. And this is sort of the throw on. Here, the falsification of the record and the possession of the gun of someone who was a non-felon and did not have a criminal record is the case within itself. So it certainly is unique.
Right. Well, it has been brought. We'll continue to follow it more next hour. Thank you, Misty.
Thank you.
Misty Marris on that at 20.